find the judge here applied an incorrect legal procedure, or if we find his statement, to me it works both ways, was meant he was operating under an improper understanding of the legal concepts, then we would, by definition, have an abuse of discretion, even if it wasn't arbitrary or capricious, would we not? By our definition of abuse of discretion.
Yes, if you find that the second and third were collapse and requires that, yes. However, I do want to point out as to the one statement that you made that the court began at the beginning. That was only a legal recognition that of the reverse Batson by McCullough that has decided by that. That was nothing more than that. It applies to both sides.
Let me just ask you, and I ask counsel the same question. It seems to me that if we do find that there's error, really the pertinent question here is, what is the remedy in this? And why don't you speak to what the remedy should be if we find that there was an abuse of discretion by not applying the right standard? What should we do?
Well, first of all, I don't think it requires reversal because of Rivera and because of good faith. I think that the remedy to send it back for remand is a difficult one, but not one that could not be accomplished if necessary. And then I also think that the court needs to consider, too, in this matter, the idea that the main and primary complaint about this particular juror was as to his views as to the death penalty and not as to guilt. This is a jury that, the constituted jury that we had here to decide these questions, especially, categorize him as a leader because he was a foreman of the jury. Sometimes foremans get picked because they're the person in the bathroom. So to suggest that he was led 6 other people that were never challenged by the defendant ever, and then 6 people who said that they would follow the law and the instructions of the court and find a verdict based on the facts and the evidence, to engage in some sort of speculation that he somehow led 11 other jurors by the nose, including one who the state had moved to strike for cause.
Excuse me. Ms. Parker, can you just refresh my memory? This juror had been challenged for cause, correct? Mm-hmm. And the reason given at that time, was it because of death penalty opinions or because of guilt opinions, or both?
Because of his strong opinion on the death penalty.
Okay. That was the only basis for the cause assertion. Okay. Thank you.
Well, I'm sorry. They did raise that at some point they raised that they thought he was sarcastic.
Right. But
it was as to a question about the death penalty, his belief about the death penalty.
But it wasn't also on the basis of exposure to pretrial publicity and a formation of an opinion of guilt.
WB, we had 3 questions at the time of individual voir dire. There were, are you gonna be biased because of the race of the defendants? Mm-hmm. How much publicity information have you received? And then the question of the death penalty. He rated high on those other 2 spaces, the race question. And this is a man, when he was asked, have you had any publicity, he was almost alone in the idea that he had heard nothing about this case until he got the questionnaire. And the reason was explored. Well, that seems quite unusual. And it was explored because this is a man who worked, as he said, 80 to 90 hours a week. He also coached a child soccer team, and he was a Sunday school teacher. And he simply didn't have time to watch the news, and when he watched, he usually didn't watch any local news. It was usually like MSNBC or some national thing, and he just had not heard about it. And so in that regard, I think that plays into the other question about WB and his level of fairness. He was one of those people who had not been exposed to the media and publicity that they complain about.
I asked counsel this question, you say basically the objection raised by defense counsel was that opinions regarding the death penalty, strong opinions about that. The guilt phase has nothing to do really with whether the death penalty is going to be imposed. Aggravators and mitigators are asked at different phases. Is it possible to have a different remedy if we find error for the guilt phase versus the penalty phase?
I think that's possible.
And refresh my memory again, WB was the only African American who served on the jury.
No, there were two. Just prior to this, that was one of the places where there was a complaint because the state had moved to strike an African American juror, a DM, and that was denied. And so that juror
That was denied based on the defendant's Batson challenge.
Yes, it was. All right.
Do you have something in particular you're moving to? I have several other questions.
Okay. Yeah, I
Should we
was
just
going
hit
to
those?
talk about the third party if the court
Sure.
wants. But,
That's fine. That's one of my questions, so go ahead.
Okay. I think that a clear understanding, and obviously this is in the record, as to what was going on as to the motion in limine to exclude third-party evidence. And at that time, we were under the Bornholt standard, and so that was what was argued in front of the court, is the direct circumstantial evidence. But I would say that what was proffered to the court doesn't even, it didn't meet the lens of Bornholt, and it doesn't meet the lens of this court's current standard, which is there must be something relevant, something that effectively connects this third party to the crime.
Something other than a defendant's testimony?
Well, in this instance, the defendant, despite what counsel says, the defendant was never, ever denied the ability to testify.
But he's denied the ability to testify about this, though.
No. And I would argue that he was not, and this is why.
Yeah, explain that to me.
Mr. Wachtel gave the opening for Reginald Carr. When he came in, he, in the state's mind, violated that very motion in limine. And also in the mind of the defendant, Jonathan Carr, because he moved for a mistrial after that. Now, prior to that opening statement, there was a sealed document of proffer that the court reviewed in light of severance. There was a severance hearing where there was a little more given, but not much, because the defense was determined not to reveal to the state their theory of the defense. So they'd given the court this document of proffer. The state's motion in limine was filed, and it was sustained unless there was some direct evidence. Mr. Wachtel came in, and then at that time made a little variation between what was originally under seal and what the jury heard in opening. And in the state's mind, again, violated that motion in limine. And what he said during that time was that there was an unidentified black male still walking the streets that committed this crime. He said that there was DNA evidence of a third black male at the Birchwood crimes, which once that all came out in the MIDO, that unidentified hair was actually Caucasian, so different from what he stated. He stated that there was, that Reginald got this property from a third male. That's how he got this stolen property and was in possession of it. After that opening, there was a discussion about whether there was a mistrial, and Paul Clark said he would not allow a mistrial. He cautioned counsel that if you have direct evidence of such, which of course if Reginald Carr had taken the stand and said all of these things he wanted to say, he certainly could have, because they would have been direct evidence. Now when this was couched right before, in the defense case, right before Reginald was suggesting to the court, I need to see whether or not I can get in this hearsay evidence, not whether or not the defendant could testify to all the other facts that he wanted to testify, that he went to this location, picked up all this property, saw a black male there, his brother was there, all of those things he could have said. But he made the choice he made the strategic choice not to testify in this matter. The only thing that the court declined, if you look at the record, was a triple hearsay statement. A statement by an unknown black male that was allegedly made to Jonathan, and then was passed from Jonathan to Reginald by telephone, and was heard by not heard by Stephanie Donnelly to the full extent, but only suggested that that made Reginald angry. So we're talking about an analysis that involves triple hearsay here. A witness, Stephanie Donnelly, making these statements about that were allegedly made by Jonathan to Reginald, but first made by the black male to Jonathan. Counsel suggests that they would fall under the hearsay exception of excited utterance or admission against interest, although counsel says in their brief that that proffer was that Jonathan said he killed people. That is not the proffer. That was never the proffer. Or that Jonathan admitted that he was at Birchwood. That was not the proffer. It's not in any of the three proffers made to the court. The proffer was that Jonathan called Reginald, that Jonathan said, there's a black man down the street tripping, talking about shooting people. Now, given that they want to make this link about the property, Reginald could have taken the stand and said, yes, I went and got this property. That's how I got it. I wasn't at Birchwood. There's nothing that ever prevented him from doing that. But it is only fair that a court would deny, somehow suggesting that this unidentified black male walks the street, and the statement we're talking about is a man that Jonathan allegedly saw down the street in front of Tronda Adams' house, tripping and talking about shooting people, with no other connection in the statement to Birchwood, no information about what the tripping statement was about. At the time of the proffer, right before Reginald's consideration of whether to testify, Mr. Evans suggested, wouldn't it be preferable if Reginald actually did a proffer himself by having an examination rather than counsel trying to express this sort of baseless innuendo hearsay? And the strategic choice was made not to do that.
Who asked that? The court or the state?
Evans, Mr. Evans.
Jonathan's counsel.
And Reginald Carr's attorney declined. Reginald decided not to testify. The court did not cause him not to testify, did not decline to allow him to testify, did not fail to allow him to present his defense. If his defense was, I was not at Birchwood and met a guy somewhere in the street in front of Tronda Adams' house and got all the property, he could well have said that. It would have met the Bornholt test.
Can I move you
Yes.
to another topic here? If we disagree with you about the charging documents on the 3 counts of rape of the males, then what happens? Then you're left with the 1 count under A6 or A4 with underlying sex offenses, but that's the same victim as under the remaining count on A6, 2 or more.
Yes.
So bottom line is we'd end up with one count left, right?
That's true, if that's the decision.
Because you do agree that the 4 counts, 3 of them are
Yes.
multiplicitous under
Yes.
the A6. Okay.
Yes, although I would, I feel confused as to how you read that to me, because in my mind it seems so clear that we identified the female as the innocent agent by initial.
I understand your argument.
So-
I'm just asking what happens if we happen to disagree with you.
understand.
Okay.
Yes,
I have a question about a very recent U.S. Supreme Court case.
Okay.
The Aline decision. You're aware of it, I'm sure. Does it have any bearing on the question of whether the aggravators needed to be pleaded in the charging document?
well, it's certainly suggestive of that. However, I would say to this court, obviously, the statute here was clearly followed, and the purpose of the lien decision and our statute is to make sure that the defendant has sufficient notice to prepare themselves. And that was in no way denied here. And so it seems to me that that would be a proper way of looking at this issue.
So the notice of intention to seek the death penalty satisfies the notice requirement?
I believe so.
Okay.
If the aggravators are specifically stated.
Yes. And they were in this instance, I believe you'll find.
Counsel, I see you're out of time. I'm going to ask my colleagues, do we have any further questions?
I may, just a second. Can you address the issue of the failure to name Reginald Carr in the count 43? He's mentioned, but not as
Yes.
the perpetrator, I think.
To argue very strong on that would suggest maybe something beyond what I'm willing to say. That was a mistake. But nevertheless, I think it was a personal jurisdiction question that was waived, and in fact, the jury was never instructed improperly. And so I believe that jurisdiction was maintained over him because of that.
On the jury view, I have a couple of fact questions. There were a couple of issues raised, but I think one of them at least has to do with a violation or alleged violation of a public trial right.
Yes.
So I'm a little unclear on a couple facts that will help me figure that one out. The plan for the jury view, I assume, was discussed among counsel and the judge in open court?
Yes, and also there was an admitted document in the file of the jury view route.
Right, I saw that.
And
Was there any reason that a member of the public or the press couldn't have followed them around?
no, in fact, in my consideration of that question, I cannot hardly see anything much more public than driving a bus on the city streets of Wichita to these 20 locations that could not be observed. So no, there was no limitation. In fact, this court had allowed the media to be a intervener party in this case. And so as to that, the media was present pretty much constantly and would be able to have done exactly what you had suggested.
How about writing on what is referred to in the record as the conveyance? Was any member of the press or public permitted to be in the vehicle that transported the jurors?
No.
Okay.
The jurors weren't.
Was there any obstacle to that? Had someone asked for that? Could that have occurred?
No one asked for that.
Okay.
I would think that would be a highly unusual situation. We don't let the press back in the jury room every time they go in recess. I would think, given the instructions given to the jury, for example, there was no court reporter either.
Right.
And that one
There
of
was
their
just the
claims.
bailiff and one officer.
That's
correct?
right. And, they were instructed not to talk about it. They
Right.
weren't allowed to get out of the bus. So, there's nothing other than actually filming their faces, perhaps, which was already prohibited in this matter. They were
Right. So
they
the
were not
state's-
allowed. So, they could maybe have a view down the end of the bus, but I don't see any obstacle in not allowing them to.
The state's
be on the bus.
specific position on this is that this was just demonstrative evidence.
Yes.
Okay.
Much in line with the ruling in Englehart.
I suppose I should have called it demonstrative aid rather than evidence.
Cooperative. I
position.
think that the Snyder case really doesn't matter whether you call it evidence. But in this matter, the court told them it was not, in fact, evidence.
Are you aware of any precedent out there that tells us what to do when, during a penalty phase, one defendant in a joint trial wants a no adverse inference instruction and the other one does not?
Well, unfortunately, in this matter, of course, the court may have tailored something different, but the adverse inference instruction that was requested actually referred to the guilt portion of the trial. And so it did pose a dilemma. I think when you consider that the jury was told that they could only consider what was in evidence, and since nothing was of that sort was in evidence one way or the other, that it would have no bearing.
But you don't know of any precedent out there about the...
I do not. I'm sorry.
Because obviously it has some bearing potentially on severance too.
Yes.
Okay. Would you like to address the issue having to do with the no instruction on whether there was a burden of proof on mitigators? Or if so, what it
Oh.
was?
Sure. I know in council suggested in their brief that maybe we could have an instruction like Florida or Maryland. And if you look at those instructions, they actually have a expression of a level of burden applied to mitigators. And in Kansas, we're fortunate to have that there is no burden at all. And I think that throughout the evidence, through the voir dire, both general and individual, every instruction the court gave, the state has the burden. In fact, the opening instruction before evidence that the court gave this jury was that the burden of proof beyond a reasonable doubt always rests with the state. So there, especially given what I mentioned earlier, their careful consideration of the evidence in the court's instructions as shown by their verdict, I would see no reason to suggest that this jury was confused by that. I recognize that there is a ruling that specifically says that we need to say there is no burden, and it's unfortunate that
That's
that
what I
didn't
was going to ask.
occur here.
In both Kleypas and Scott,
Yes.
we specifically said what the jury is to be told, and the jury was not told that in this case.
Yes.
But you
One more
just are saying no
question.
harm here.
Yes.
Okay.
Dr. Pay's testimony at, in response to Dr. Preston's testimony, I'm curious about just how the procedure of that. You waited until after Dr. Preston testified, I think, is how I understand the record, called up Dr. Pay and gave him this. I mean, there was no attempt to try to get any kind of evidence prior to Dr. Preston's testimony to rebut it?
Yes, there was.
There was.
fact,
Explain to me the process, because
There
maybe
were-
I misread that.
Yes. There were numerous attempts throughout. It's almost akin to we don't want you to know the theory of the defense to the state. And I'm not suggesting that that's not legitimate.
Right.
I'm just suggesting that was the position we were in. So there were multiple attempts to obtain reciprocal discovery for expert. And the night before Preston testified, we were finally given these documents. We knew that Mr. Carr, Reginald Carr, had been taken to this particular group to have these PET scans done in Wichita, which Dr. Pay was part of. He was the doctor that originally, with Susan Stratton, who's mentioned, a technician.
So my question was, you didn't get Dr. Preston's testimony until very late
Right.
into the
So-
sentencing? Okay.
And so what happened during that process is that Dr. Preston is actually on the witness stand, and the slides are being shown. And there is a specific exhibit, I believe it's number 39, which was to be a blow-up of those slides. And actually, as sitting there at counsel table during the examination, I was trying to compare that larger blow-up to the smallers, and I was finding no comparison. So because of that, we sent an investigator out to find out where these were made and what had happened there. Now, Dr. Preston had already testified that there was some adjustment of the camera and also testified that there was a reduction in the color that he asked this technician to do. The technician confirmed that. Dr. Pay was asked to look at this particular slide, and he said because of the reduction and because of the adjustment of the angle, it didn't actually show the areas of the brain that Preston had suggested were damaged. In fact, it didn't show that the amygdala and the uncus at all.
So what would have been wrong with allowing surrebuttal in that instance for Preston to come back and say, well, no, I did, or whatever he was going to testify to, but to explain the difference between his own exhibit and what Dr. Pay testified to? Why wasn't he allowed to do that?
Well, first of all, the exhibit itself, the state's exhibit, which was the only new evidence that they suggested, the state's exhibit was the exact same slide. It just had the state's number on it as the defense exhibit in question. Maybe there perhaps wasn't anything wrong with it. In fact, I think the court encouraged it, said he would wait. He said, you can use my phone to call him to find out if there's something different. So the defense went back and called. They came back and explained the only thing different would be we could ask him about state's exhibit. And then the suggestion was made, well, that's the same exhibit as the defendant's. And so the court decided there's nothing really new, but was open to the idea that the man could come back in and say something different, which they did not suggest that he could.
Do we have any further questions?
Yes, I do. Just have a couple left. First, I'll ask about something related to the Dr. Pei
Okay.
testimony. Another issue that's arisen is his reference to a consensus among several
Yes.
people who did not testify. And I think at several points during his testimony, he indicates that someone is in the courtroom. Was every single person involved in the consensus in the courtroom or not?
I believe all the doctors in the group that he worked with, that he consulted, including the technician, Susan Stratton,
Okay,
were all in the courtroom.
all present. Okay,
And-
that was my only question. It's just whether they were present in the courtroom, because obviously that has an effect on hearsay analysis. The other couple questions I have left relate to issues raised by Jonathan, but that might be considered unassigned as to Reginald.
Okay.
Are you the person who's going to argue this afternoon?
No, Mr. Loudon is going to
Okay.
argue Jonathan Carr's.
If you don't know the answers, then maybe we'll get them from him, but I'll go
Okay.
ahead and ask them of you.
All
and
right,
we'll see where we
that's
go.
fine.
Okay. He makes several arguments related to aiding and abetting.
Okay.
Is there any reason that whatever merit exists or does not exist in those arguments would not apply also to Reginald, that you can see?
Well, I'm not sure what
just
arguments
about,
he
talking
makes.
just about guilt, first of all.
Mm-hmm.
He makes several arguments about how aiding and abetting comes into this case,
Mm-hmm.
many of which seem to assume that the jury convicted Jonathan on an aiding and abetting theory. We'll talk to them about that this afternoon. Just assume with me for the moment that those arguments either do or do not have merit. We don't know, do we, what the jury which theory the jury convicted on either of these men, whether it was as a principal or an aider and abetter? We just don't know, do we?
No, but I would say this, is that, first of all, they were presented with a document that, in the verdict form, et cetera,
Mm-hmm.
with the idea that we have them both as principals.
Right.
And frankly, they were charged as principals
Right.
with that intent in theory. That was argued throughout, that there was essentially no aider and abetter with some sort of minor role in this matter.
Right.
They,
It's a joint enterprise, and we didn't know who the shooter was, right?
yes,
Okay.
in fact, even without, of course, knowing who the shooter was, there was always the possibility that the gun was passed off, which may seem unlikely, but at the same time, they were both present. Jonathan led the way to the field.
There was evidence that there was enough time between the first shot and the subsequent shots for someone to say something.
Yes.
Okay. I think you've answered my question. I just wanted to make sure that in your mind there wasn't some distinguishing mark between the two defendants on aiding and abetting, as far as you can.
No, in fact, their theories, of course, is that they weren't there. So the only theory to adopt would be the state's continued pounding of the idea that there was equal premeditation, equal participation, and that both were principals in this matter.
Okay. We talked a moment ago about a specific count and an error that was made. There apparently is a garble, according to the transcript, too, when Judge Clark talks about the situation where the jury would be unanimous as to the existence of aggravators, but not unanimous as to whether they outweighed, or the reverse of that. That's pointed out, I think, in Jonathan's brief.
Maybe. I'm sorry, I
prepared
have
to
not
address that at
prepared
all?
myself for that argument. But
Okay, alrighty, because I don't know why that wouldn't apply to Reginald as well. That's why I'm
Right.
giving you an opportunity while you're
Okay,
here.
thank you.
Alrighty. And I guess that's it. Thank you.
All right, thank you.
Do we have any further questions? Any further presentation, counsel?
No, it's an honor to be here. Thank you.
Thank you. And you had reserved 5 minutes for rebuttal.
It may take me 5 minutes to get up to the podium. Justice Fire, we actually did raise the aiding and abetting issue. That is our issue number 38
Okay.
in the first supplemental brief that we filed. Justice Lukert, I think that the fact that the defendants were very concerned during jury selection about the fact that they seemed to be running out of African American jurors, and the fact that the defendants actually imposed, or at least Reginald did, imposed their own Batson challenge when the state tried to successfully remove the first African American, and then the court sustained the defense's second Batson challenge. I think that only cuts one way. You had asked if maybe it cuts both ways. I think Ms. Parker actually made our argument for us. The fact that the defense was very concerned about the fact that African American jurors seemed to be disappearing from the panel, but then went ahead and tried to remove WB, shows that they weren't motivated by racial considerations. If they were motivated by racial considerations, they would have acquiesced in the state's removal of 2 other African American jurors from the panel. And I think this fact, go ahead.
And there was a Batson challenge injected with regard to the one that was excused. In other words, the defendant raised the Batson challenge on both of the other 2, right?
I'm not sure. I know the defendant did on the second one. And I just would be talking out of school if I said they did it twice, because I just can't remember. But it's clear that there was no racial consideration in trying to remove WB. And I think that fact standing alone can feed into our abuse of discretion standard. This court can find abuse of discretion for 2 different reasons. One reason, if the judge didn't follow the proper legal standards, which I think we've established in our brief. But the other reason is if the court makes factual determinations that no reasonable person would agree with. And I think that meets this situation. I heard Justice Johnson ask again and again, what could the judge have possibly based this finding of discriminatory intent on? And there's really nothing in the record. Justice Johnson,
Just before you move on from that,
Yes.
but isn't there, underlying Batson, underlying it, taking a step away, is that we have diverse juries that reflect our communities throughout the state. And is it permissible for a judge to take that challenge, that principle that underlies Batson, into account as he or she sees the dwindling population or the minorities that occur through the peremptory and the whole voir dire process? Isn't that a factor that can kind of be looked at in making this determination? Is it permissible?
no.
You're just, what?
No.
No, it can't be?
It can't be, and that's the holding of the Pellegrino case, because that's cited in my reply brief, and that's exactly what the judge was trying to do in the Pellegrino case. He was trying to achieve a racially diverse jury, and by doing that, he required the litigants.
But that took precedence. I'm just saying, can it be a part of the factoring? In the
No.
Pellegrino case, that was the sole reason that he
No,
gave.
it cannot be. The judge is tasked with determining if the state has met its burden of proof of showing that the proponent.
Pellegrino was the extreme. I'm not talking about the extreme. I'm just talking about, can it be a factor?
Right. But I think the exact same thing was going on here. To me, it works both ways. To me, it works both ways. You interpose these Batson challenges, and now I'm going to not let you remove an African American juror. That's not race neutral. That is not race neutral. Justice Johnson, you were talking about this joint trial issue, and you were talking about the prejudice of having I'm going to paraphrase you, the obviously guilty brother accusing his brother of also participating in the crimes. I think that just look at the closing argument that Jonathan made. Reginald took the lead in these crimes. The gun belonged to Reginald. Reginald did the shooting. The eyewitness identification should be believed. Reginald had the stolen property. Reginald drove by the residence. DNA ties him to the crimes. And finally, I, Jonathan, would have been on a train to Cleveland, but for my brother, Reginald. In this case, you have the obviously guilty brother claim that Reginald was guilty too. And the jurors didn't know in the guilt phase that it was important to Jonathan that Reginald be found guilty as well, because if Reginald wasn't found guilty, then Jonathan's mitigation evidence wouldn't really have carried any weight with the juror. And I did cite
What about your opponent's argument, though, that that's all just argument and not evidence?
That's exactly what I was getting to, Justice Lukert. I did cite this court on page 91 of the opening brief to the Neal versus State case, in which the Oklahoma Court of Criminal Appeals said the specific accusations made by each defense attorney in opening statements, closing arguments, and cross-examination of the state's witnesses created the antagonistic defenses. Likewise, in United States versus Romanello, which is also cited in my brief, the court found that the establishment of antagonistic defenses doesn't require that one defendant take the witness stand and accuse the others. The lawyer's accusations can suffice. The quote from the state is, "An accusation by counsel can state the core of his client's defense and cast blame on the co-defendant. The real question for a court in considering a severance motion is not how convincing a defendant's evidence is, but whether the core of his defense directly indicates or implicates the co-defendant." And clearly, the core of Jonathan's defense directly implicated Reginald.
The state really doesn't take much issue with the fact that there are antagonistic defenses, and I think that's what that quote goes to, is whether they exist. They say, yes, they exist. But they say the evidence would have come in the same.
I'm sorry?
They say the evidence would have come in the same, that there was nothing added. And if you'll recall, I think with your opposing counsel, we tried to get her to focus first on the guilt phase and then on the penalty phase. Would you do that for us?
Yeah, well, I'll parrot Justice Johnson with regard to his comments with regard to the guilt phase. And just kind of what I've alluded to also. Yes, the state had a lot of evidence, but the jury had the right to view it with a high level of skepticism or a low level of skepticism. And as I pointed out, there were problems with the state's case with regard to Reginald. But when his co-defendant and brother cast the blame for these crimes on Reginald through his attorney, that meant the jury was going to view the state's evidence with a much lower degree of skepticism than they might have if the obviously guilty guy wasn't pointing the finger at his brother as well.
And you know that how? How do you know that the jury's going to view that with first skeptically or however you want, and then when the defense is raised that validates that? How do we measure the impact that has on a jury when it is not new evidence? Mm-hmm. How do we measure that?
Well, I think you look at whether it was just fundamentally unfair for Reginald to have to be facing two accusers. And I think you do look at the impact. I think you can use your experience as a jurist and look at the impact of one witness saying Reginald is guilty compared to the impact of one witness saying Reginald was guilty plus the co-defendant, his brother, saying that Reginald was guilty. And there is a quantum of difference in the evidence in that case. I mean, you have an eyewitness who said Reginald was at the scene. Reginald was committing these crimes. But remember, the eyewitness failed to identify him on one occasion, and the eyewitness made that probable misidentification when testifying about the sexual act. But if you have the co-defendant who, as the state pointed out, I think they said he sowed his seed all over the crime scene. When you have the co-defendant, who's also the defendant's brother, basically saying through counsel, Reginald was there and I wouldn't have done this but for Reginald, then suddenly any question you might have about the accuracy of, say, the eyewitness identification, that's laid to rest by the co-defendant's accusations. Now, I think Justice Beyer asked me to address prejudice in the penalty phase as well.
Well, she also asked you to address the question or the state's argument that it would have come in anyway. Jonathan could have been called. If he was tried first, he could have been called as a witness in Reginald's trial.
Well, that's pretty speculative. I don't know what. Well, I'm not sure about that. I don't know that Reginald would agree to testify. You know, if Jonathan were tried first
Well,
and.
that's your answer to her question is that no, all of the evidence would not have been there. Is that
Right.
what you're saying?
Right, we can't say that in the penalty phase,
That in separate trials, the
Right.
evidence may not have been, the evidence would have been, but the characterization and his testimony or his argument that the brother was there may not have come in. Is that
Correct.
your argument?
correct. And then, of course, in the penalty phase, we have the state getting in Jonathan's statements that, you know, under Bruton wouldn't have been allowed against Reginald about here's why we raped the one victim. We have Jonathan eliciting testimony from Tamika that Reginald had confessed to the crimes too. So the prejudice, I think the prejudice was greater in the penalty phase, since the whole gist of Jonathan's penalty phase was Reginald was at fault in all of these, and I wouldn't have committed these crimes but for
That
Reginald.
sort of cuts both ways because it may have been more prejudicial, but it's more likely that it could have come in a separate because you don't have the evidentiary constraints at the penalty.
You mean if Jonathan had agreed to come in
If
and
it had been
testify?
separate, then Jonathan's statements may have been more likely to come in on the penalty phase because you don't have the hearsay.
Relaxed
Yeah,
evidentiary standard.
yeah, you have the relaxed, so it cuts both ways for you.
But what we have is the record as we have it.
Do we have any further questions? I see none. Thank you, counsel.
Thank you.
Thank all counsel for your arguments this morning. The court will take this matter under advisement.